Good morning to everybody. Welcome to the today class. And today the topic that I am going to cover is the law of contract, which is for the All India Bar examination, sitting people or appearing people. And I'm sure that you are hearing me. If you are hearing me, please unmute and read what I posted on the screen. Unmute and read what I posted on the screen so that I could know that you are hearing me and I'm hearing you. Yes, anyone? Unmute and speak what I posted on the screen. I repeat.
Good morning, sir. With
Well,
great devotion, fervor, and gaiety, with the rays of joy and hope, wish you and your family happy Makar Sankranti. Thank you, sir. Thank you very much for
yes, that is the thing that I made it to the everybody. Say good morning to the legal fraternity with great devotions forever and gaiety, with the rays of joy and hope. Wish you and your family happy Makara Sankranti. Professor Dr. Muhammad Saib Hussain, voluntary online class professor of law. Yes, with this, I would like to turn to my
great,
teaching.
great.
Yes, that is All India Bar Examination, Indian Contract Act, the
Great
18.
service, sir.
Yes, sir. A service to man is a service to God. That I believe in that theory. That's why I'm doing it. Because the time is short. Hence, I want to cover the many things so that you would have to get the good marks. That's my wish and that my the desire also. Let us come to the point of the first question is what does consideration must move from the promisee mean? Consideration move from the promisee means consideration must move from the promissory or consideration must move from the promisee or only A will be the right answer or none of the above. So consideration from where it moves, the answer is
Yes,
consideration
sir.
must B. Consideration must move from the promisee. Thank you very much. There is a rule of consideration must be moved from the promisee. This means that the person to whom the promise is made can only then enforce the promise of they have provided consideration for it. There is no corresponding requirement that consideration moves to the promisor. So that is the feedback for that one. The second question is the Indian Contract Act 1872 defines the term contract under which section? 2E, 2F, 2G, or 2H? Yes,
2H, sir.
2H is the right answer for that one, and that is the definition of the contract is defined in the Indian Contract Act. The third question is a stranger or a person who is not a party to a contract can sue on a contract in the following cases. What are the following cases can be even though a party is not to the contract and they are the stranger to the contract, they are the third party, but still they can sue in the contract. Who are they? A. Trust.
All of the
B. It is
all
a
of the above.
answer is all of the above. Number one, the trust. Number two, the family settlement and assignment of a contract, and all of the above. The answer is all of the above. Every person, those who are not the party to the contract, also can sue, even though they are the third parties. So next, a minor is a person who not attained the age of 18 years as per the dash of the Indian Contract Act 1872. Which section says?
Section 10, sir.
It is a section 11 which says about this thing regarding a minor is a person who is not attained the age of 18 years as per the section 11 of the Indian Contract Act 1872. That is the answer. Next question is Khan Gul versus Lakha Singh was the second leading and landmark case law under the Indian Contract Act 1872, which deals about number one, gratuitous contract, number two, minor contract, three, C, stranger contract. D, privity of contract.
Privity of contract.
No, it is a minor contract. The reason is the second largest, I say, the second leading case law. In the a minor contract is wide ab initio. What is the landmark case law? Feedback. This is the subsidiary question. It is not there on the screen.
Moinuddin,
Mohiri
Moinuddin,
Bibi versus
Moinuddin versus
Mohiri Bibi versus Dharmadas
Moinuddin.
Ghosh.
Yes, sir.
That is the leading case law where the minor contract is wide and That is the second, the landmark case law is Khangul versus Laka Singh, where the minor contract is void because minor doesn't have the capacity to understand the contract. Yes, next
This
question
is
is, yeah. So next question is, in which case law it was observed that while there is no capacity for a minor to contract, a minor will have an obligation to repay a supplier for the services rendered if the supply is for the necessities, and if it was proved that there was enough supply of these such things that it will not come under the shade of the or the tag of the necessities. In other words, a minor and already had enough clothing in this case, which supplied a minor's father, and the contract could therefore not be said to be for the necessities. What is that case law?
Nash versus Inman.
Yeah, which is the here which I have given the choice here. Which is the right correct answer? A, B, C, D.
C.
Yes, very good. It's the Nash versus Inman. Nash Nash. The first one I made Nas double H. No, that is wrong. Nas IN double N last N double N. That is wrong. And the correct one is the C. The Nash versus Inman is the correct answer for that one. Now you can tell me what is the case law which is known by famous by three-piece suit case law.
3.
Three-piece suit. Trouser, coat, waistcoat. Three-piece suit case law. Here I have given the even the model also. I have given the diagram also. Sir, in the diagram you can see the tie also. But generally tie will be not stitched with the tailor. Only the coat will be stitched with the tailor, and the trouser or the pant will be stitched with the tailor.
Miller and Jackson, sir. Miller and Jackson.
That means still you did not have any knowledge about the case law. Nash versus Inman, that is the case law. It is a Nash versus Inman is the case law, three-piece suit case law, and the other cases are not because the feedback is Heaven versus Panda is the court of is the English law case, which is foreshadow the birth of the modern law of negligence. That is the Miller versus Jackson is the famous court appeal of England, Wales in the torts of negligence and nuisance. And Donegal versus Stevenson, and you know that it is a Scottish case law. It is regarding the duty of the care should be taken over there. That is the case law. So Nash versus Inman is a three-piece suit player where the he supplied the many suits, the tailor, but it is not necessary because the father has given the many suits over there. That's why it is not necessary. Hence, it will not be covered over there, and a minor will not be held liable. Okay, now you tell me that under the following cases in which minor contract is a valid contract. Under the following cases in which minor contract is a valid contract. Mohiri Bibi versus Dharmadas Ghosh. Yes?
Chapel
No.
versus
It is a
versus
chapel. It
Chapel.
is a chapel. I have given the feedback also here. It is a chapel versus so and so. It was held that the contract made by the minor for the burial of her deceased husband was a contract for the necessaries because the deceased husband means she is the minor and this is husband. However, where the contract for the necessaries is not decided on the objective basis of the requirement for the living of an entirely abstract, reasonable minor, the test is relative. It is a dependent. It is dependent upon the age of the social situation of the particular minor. Suppose the minor is a very rich man, so the motorcycle is a necessity, not bicycle. Yes, that is the thing. The Khan versus Gul, where the case law requires that the parties must be competent to contract because the party is a minor over there. Okay, next comes the A agrees to help B. I repeat, A agrees to help B build his house since they are friends. Is this a contract? This is I
No,
took it from the IAB.
no, sir.
Then what it
How
is?
can, how can it be a contract when there is no consideration?
No, no. Which is the correct answer? Because here A, B, C, D I have given. Which is the correct answer?
B.
The intention
It is the C is the
to
correct
create a
answer.
relationship.
It is the C is the correct answer. Intention to create a legal relationship is not over there. Hence, we can say that though it resembles, of course, there is no contract at all, but answer should be given specifically because I have specifically mentioned the intention to create a legal relationship. Can you tell me the another case law which is not given over here? But can you tell me that case law name where the flick knife is put it over there and it is for the window shopping, and he filed a case on the offensive weapons act. But the case law decided that it is not a sale nor a offer for a sale. It is the intention to create the legal. It is merely the intention to create the. It is the invitation to treat, not intention. It is merely an invitation to treat. Can you tell me what is that case law?
It is
Flick knife, that is a button chalk case law. అది కిటికీలో పెట్టిండ్రు. కిటికీలో పెడితే వాళ్ళు ఏం
Sir, you
చేసిండ్రు?
know the facts, but you forgot the case law name.
అదే కదండి అడిగేది. ఇప్పుడు చూడండి. Yes, now you tell me.
Fisher versus Bell.
It is the Fisher versus Bell case law whose facts I have given over there. Then ABCD, which one is the correct answer for here?
Invitation to potential customer to treat.
This is the same which I told you now, and you have to make it very much easily. Just you apply the IQ, that is enough. 11th is, read the 11th one, please unmute and read.
The prescribed period of limitation for a suit of special performance is dash from the date fixed for performance. 3 years, sir.
Yes, this is I have taken for the IIB. Just I want to test you. But general contracts are concerned. Subsidiary question. It is not there. It is not there on the screen. Subsidiary question. If the general contract is concerned, what is the limitation period?
3 years.
No, 6 years. General contracts are concerned, unless it is specifically mentioned over there. Yeah, a contract to which the central government or a state government is a party is strictly called. I think it's a very easy question.
Concurrent.
Government contract.
It is a government contract. Don't say central government contract. Don't say state government contract. Don't say concurrent contract. It is not the concurrent list. So better you say the government contract. That is the appropriate answer, because such a thing also will be asked. And at the time we should be very much cautious enough, and your IQ should be applied over there. Yes, sir. In Mohri Bibi versus Dharmadas Ghosh, the outcome of the case was, what is the outcome of the case?
B. Minor agreement is not agreement in the eyes of law.
Yes, that is exactly the case law. Yes, minor agreement is not an agreement in the eye of the law. That is exactly the words you should have to use it. Yes, you read the 14th question.
Dunlop Pneumatic Tire Co Limited versus Selfridge Limited. AC 847 made it clear that Dunlop could claim for damage in the circumstances. Dunlop could not claim for damage in the circumstances. Done the above A and B are correct, none of the above.
Which is the right answer?
Sir, A is the answer, sir. Dunlop could claim for damage in the circumstances.
Dunlop could not claim for the damages in the circumstances because Selfridge company is a third person.
Norfolk.
Yeah, Selfridge is a third person, so you cannot bring an action against the third person, because they are not the party to the contract. The party to the contracts are different. Please read the case law and again once again, so that you could know that what is the exact answer for that one. Yes. 15. Which of the following is a vis major or a force majeure? We should not say force majeure. Force majeure. That is the pronunciation. Force majeure.
Volcano and earthquake.
Extraordinary rainfall, time immemorial. All of them is the right answer. This is a tapped from the IIB, because one of the question, I should be very much thankful to Vinay Charles. He posted so many IIB, but the way that you read is not the way you have to learn it. The way that you read is you have to participate in, you make the discussion, and that is the best way to learn the things. Yes.
Suddenly we should not jump to conclusion until we see all the answers.
Yes. No. Unless until you are very much thorough on it, yes, you can jump into it, because better you have the glance on the total 4. Then automatically your IQ lead, immediately your finger go to the particular point, because you read it, and if you not read it also, if you heard also, that you could it will come to your memory. Yes. 16th question is, void contracts include the things like the following: A, B, C, D. Contract between the legally incompetent parties or minor. Contract that restrict the trade. Contract with uncertain material terms, or all of the above. The answer is all of the above. Because wide contracts include, I said, wide contracts include the things like the following. Means all of the above are wide contracts. Which one are not wideable contracts include the following. See, wideable contract, not wideable contract. Yes,
One part. Contract with the party that has been contract with the party.
yes.
Also,
Answer
Contract, contract with a party
is
where
a
one
major.
party is major. Where one
See,
party is
I just removed the minor, I put you the major over there, then it becomes a viable contract automatically, which is not. I say not negative. That is a very much important factor. To secure the performance and enforceability of the contract should be
void contract.
a valid contract.
a valid contract is the right answer for that. Just apply the brain. Just apply the brain, you could know the things, what is the difference between it. A contract may be considered dash when the terms are worthless, particularly for the one party.
Voidable contract.
C.
Yes?
Voidable,
C.
sir.
No, this is I tapped from the IIB. I tapped from the
Contract.
Vinay Charles, and courtesy goes to him. Nugatory.
Are worthless. Only one party
One party.
deviates. If one party deviates only, it is voidable. If both parties are okay,
No, we can say, you can particularly we can say it is a nugatory contract.
when the terms them are worthless to one party only, it is voidable, kada.
Hmm. But we can use the both wideable and nugatory also because both are right there. Because one party is only making such a thing, the other party is ready. Then it becomes a wideable, and the nugatory also it becomes is another word. Of course, the nugatory word we don't use it in our. Did you use the in the contract act a nugatory?
No,
No,
no.
sir.
No. This is only British terminology. Like civil law terminology is a force majeure, and common law terminology is a vis major. So I am sure that it is both available as the nugatory is the both right answer for the question. Okay, this is the tapped from the IAB. So courtesy for the Vinay Charles. Wager relates with
Future events.
అన్ని
Actions
చదవాలా
of an event.
అన్ని చదవాలా
Any of the above.
ఎనీ ఆఫ్ ది అబో అది ఫ్యూచర్ కూడా కావచ్చు, ప్రజెంట్ కూడా కావచ్చు, పాస్ట్ కూడా కావచ్చు, ఏమన్నా కావచ్చు. ఇట్స్ ఆల్ ఆఫ్ ది అబో ఇస్ ద వేజర్. వేజరింగ్ కాంట్రాక్ట్ ఇస్ ఏ కాంట్రాక్ట్ సబ్సిడరీ క్వశ్చన్. సబ్సిడరీ క్వశ్చన్ అంటే స్క్రీన్ మీద ఉండదండి.
The concept of
Subsidiary contracts, sorry, wagering contracts are wide contracts, or wideable contracts, or nugatory contracts, or illegal contract. అసలు వేజరింగ్ ఎప్పుడు కదా, వేజరింగ్ అంటే గ్యాంబ్లింగ్ గుర్తుపెట్టుకోండి.
okay, sir. Wager and gambling.
గ్యాంబ్లింగ్ గుర్తుపెట్టుకోండి. ఏమైతుందండి గ్యాంబ్లింగ్?
That is illegal.
ఇల్లీగల్. ఇల్లీగల్ అండ్ వైడ్ ఆల్సో, బోత్.
Void also. Yes.
అంటే ఆబ్జెక్ట్ ఈజ్ బ్యాడ్, ఇట్ ఇస్ ఇల్లీగల్. Object is good, but it is a wide because it is not enforceable in the court of law. But contingent contract not.
But some clubs and horse racing, sir.
Oh, that is only the exceptional cases. That is the exceptional cases. The clubs and race course is only the exceptional case. Lottery.
The wager is
Yeah.
against public policy.
Yes.
Unless the government itself takes up lottery.
License. The government itself has given the license. ఇప్పుడు కెసినో ఉన్నది, కెసినోల్లో పైసలు పెట్టరు, ఏం పెడతారు? ప్లాస్టిక్ కాయిన్స్ పెడతారు అక్కడ.
Yes, the government has given license.
And a race course, the government has given the license. Lotteries, the government has given the license, even though they are wagering contracts.
The private lotteries are they are void.
Yeah, private or they are wide, unless it is run by the government. Of course, when they run by the government means the government only. Yes, come to the next point is the concept of the privity of contract was rejected in the case of ఎందులో రిజెక్ట్ అయిందండి?
That is Carlyle versus book wall.
No, no, sir.
No, water bottom versus right.
Winter bottom was.
Bottom versus right.
It's not A and C, sir. It may be B or D.
No,
మీరు
sir.
డొనోగా వర్సన్ స్టీవెన్సన్ చదివినారు కదండి.
Donoghue versus Stevenson.
మరి థర్డ్ పార్టీ అని అండి వాడు జింజర్ బీర్.
కాదు.
మరి
Privity of contract.
ప్రివిటీ ఆఫ్ కాంట్రాక్ట్ అక్కడ ఫాలసీ అయింది కదా.
Donoghue versus Stevenson, sir.
ఇస్ ద రైట్ ఆన్సర్. మరి కార్లిల్ వర్సెస్ కార్బోలిక్ స్మోక్ బాల్ సబ్సిడరీ క్వశ్చన్ ఫేమస్ ఫర్ వాట్?
Newspaper ad.
కాంట్రాక్ట్ లో టైప్ ఆఫ్ ది కాంట్రాక్ట్స్ ఉంటాయి. కైండ్స్ ఆఫ్ ది కాంట్రాక్ట్స్ చెప్పండి. అడ్హెసివ్ కాంట్రాక్ట్స్, స్టాండర్డ్ ఫార్మ్ ఆఫ్ కాంట్రాక్ట్స్, bilateral contracts, unilateral contracts.
Unilateral, sir.
Unilateral contract aitadi. That is the okay. So winter water అని చెప్పండి. దేనికి ఫేమస్ అది? ఈ థర్డ్ పార్టీ కెనాట్ బి సూడ్ అన్నాడు దాంట్లో వింటర్ బాటమ్ లో. థర్డ్ పార్టీ కెనాట్ బి సూడ్ అన్నాడు వింటర్ బాటమ్ లో. హెవెన్ వర్సెస్ పాండార్ ఇది వేరే కేసులో, అది థర్డ్ కేసులో ఇది. Okay, the Indian Parliament has recently caused an amendment which is related to a bank or financial institution stipulates a term in guarantee and to limit the time within the which the guarantee to a particular dash section of the Indian Contract Act 1872. పార్లమెంట్ ఒక సెక్షన్ కి చేసింది. ఆ సెక్షన్ ఏం చేస్తుంది? గ్యారంటీకి అంటే ఫైనాన్షియల్ ఇన్స్టిట్యూషన్స్ ఆర్ బ్యాంక్ కి గ్యారంటీ ఉంటుంది కదా, దాంట్లో మార్పు తీసుకొచ్చింది.
27. 27.
It is 28 is the right answer for that one. Undue influence cannot be inferred merely because family members was taking care of elderly person was observed in the case of yes
Rajaram versus Jaini Prakash Singh.
Raja Ram versus Jain Prakash Singh. That is the right case law. Raj Ram versus Jain Prakash Singh is the right case law. So that is the case law which will be there. Yes, a bailer was bound to take as much care of the goods bailed to it as a man of ordinary prudence would under similar circumstances. If any negligence on behalf of the bailer, then bailer is liable for the loss under section dash of the Indian Contract Act. అంటే బెయిల్మెంట్ సెక్షన్ ఏంటిది అన్నట్టు అర్థం.
Section 153.
బెయిల్మెంట్ సెక్షన్
153.
if the bailer is held responsible for that one, then it is a 151 is the right answer for that one. Feedback. Union of India versus Mrs. Udo Ram Sons. In this case law, the respondent sued the railway authority for damages for the loss, but the railway authority taken that no, we take a lot of care, it is not in our hand. But later on they say the Union of India appealed to the Supreme Court, held that the responsibility of the railway under the section 72 of the Indian Railway Act is subject to the provision of the section 115 of the Indian Contract Act, and a bailer was bound to take much care of the goods bailed to it as a man of ordinary prudence would under similar circumstances. The loss having taken place due to the negligence of the railway servant, the railway is liable for the loss incurred by the respondent. Yes, this is the thing where a person lawfully does anything for another person or delivers anything to him not intending to do so gratuitously, and such other person enjoys the benefit thereof. The latter is bound to make the compensation to the farmer in respect or to restore the thing so done or delivered by virtue of which section of the Indian Contract Act 1872. అంటే ఇది ఏం లేదు, ఇది గ్రాట్యుటస్ యాక్ట్స్. It covers under the 69, 70, 71, 72. The right answer is section 70. Section, suppose their law bounds that he has to pay it, but somebody is paid it because that he wants to give it, but it doesn't mean that he has given the gratuitously. So that is
Estoppel, principle of estoppel.
estoppel is a little bit different for this one because when you say something, you have to hold it. That is called the estoppel. Yeah, mute because I'm getting the other sounds also here. So when you want to speak at that time, you can unmute and speak. Okay. The law on liquidated damages is governed by dash of the Indian Contract Act 1872. Liquidated damages ఏ సెక్షన్ కింద గవర్న్ అవుతాయండి?
73.
74 is the right answer for the అసలు లిక్విడేట్ డ్యామేజెస్ అంటే చెప్పండి, సబ్సిడరీ క్వశ్చన్.
Which can be measured.
Which can be measured, which can be ascertained, which can be determined, which can be agreed by the both the parties prior to the contract or in the contract. అది liquidated.
It means which can be measured.
ఇప్పుడు టాటాలో ఏ డ్యామేజెస్ అయితాయండి? సబ్సిడరీ క్వశ్చన్స్.
Unliquidated damages.
Unliquidated damages అవుతాయి. The following cases are the deals about the which section of the Indian Contract Act? Kailash Nath Associate versus DDA, ONGC versus Sapipes, Fateh Chand versus Balakrishna, Kishan Das, and Maula Bucks Union of India. That is the Maula Bucks. ఏ సెక్షన్ ఇవి 4 ఒక సెక్షన్ కి డీల్ చేస్తాయి. ఏ సెక్షన్ కి డీల్ చేస్తాయి? 71 72 73 74 పోనీ హింట్ కూడా ఇచ్చేస్తా. డ్యామేజెస్
71.
హింట్ కూడా ఇచ్చాను కదండి డ్యామేజెస్ అని.
Actually, it is 72.
అయ్యా ఇప్పుడు పైన ఈ హింట్ ఇచ్చానా నేను? లిక్విడేటెడ్ డ్యామేజెస్ ఏ సెక్షన్ల కింద కవర్ అవుతాయి?
73, sir.
అయ్యా ఇప్పుడు చదివినారు కదండి. ఇప్పుడు మీరు ద లిక్విడేటెడ్ డ్యామేజ్ ఇస్ గవర్న్ బై ద సెక్షన్ 74. ఇది కూడా మొత్తం లిక్విడేటెడ్ డ్యామేజెస్ గవర్న్ అవుతుంది దాంట్లో. A liquidated damages naturally it depends upon the nature of the damage which is happened there. It varies from time to time, so that all that is where the Supreme Court has given the different directions based on the 74, that is the liquidated damage in the contract. అవన్నీ 74 కింద డీల్ అవుతాయి. Yes, Indian Contract Act is one of the oldest dash of our country. Yes. అది బిజినెస్ లా అండి, ట్రేడ్ లా అండి?
Mercantile law.
Answer is mercantile law. That is the right answer. This is I covered in the LLM entrance examination also. The final draft of the Indian Contract Act 1872 was the work of, yes, who are the people?
Poland.
Answer is
Both.
A and B. That is Sir James Fitzjames Stephen versus Sir Frederick Pollock. So what is the another subsidiary question? Where the Sir James Fitzjames Stephen is famous for? Father of the law of evidence. Subsidiary question that is. Okay, the Indian Contract Act 1872 consists of how many sections? Yes.
238.
Huh? Repeat.
238.
Very good, very good, very good. Electronic contracts or e-contracts are also known as
Modern contracts.
They are called cyber contracts, or we can say electronic data interchange contracts. There is a specific name is given over there. E-commerce. So, what or which sections are repealed in the Indian Contract Act 1872?
Option B, sir. 239 to 266.
Yes, it is both A and B. It is both A and B. Chapter 7 sale of goods, it is also repealed. Chapter చెప్పండి చాప్టర్ ఎంత అది? రోమన్ లెటర్ చెప్పండి, చదవండి, చదవాలా?
Chapter 7, sale of goods, section 76 to 123. Chapter 11 of relationship, partnership, section 239 to 266 and schedule.
ఈ అన్ని ఏమంటారండి? నేను చెప్పాను మీ క్లాస్ లో
both A and B, sir.
యా దట్ ఆన్సర్ ఏ అండ్ బి, దట్ ఇస్ ఓకే. ఈ అండి సింబల్ ని ఏమంటారండి? ఈ సింబల్ ని ఏమనాలండి? ప్రొఫెసర్ హుస్సేన్ స్టూడెంట్స్ చెప్పాలా మీరు?
Both A
ఆంపర్సండ్.
and B, sir.
అది ఆన్సర్ కాదండి. అండ్ సింగల్ సైన్ సింబల్ ని ఏమంటారని అడిగాను. మళ్ళీ మీరు బోత్ అండ్ ఏబి అది అయిపోయింది. ఈ అండ్ సింబల్ ని ఏమంటారని అడిగాను. అదే మరి అందుకోసం చెప్తాను, ఎందుకు చెప్తలేరని. ఓకే, నెక్స్ట్ జనరల్ ప్రిన్సిపల్ ఆఫ్ లా ఆఫ్ కాంట్రాక్ట్ ఇన్ ఇండియన్ కాంట్రాక్ట్ యాక్ట్ 1872 రన్స్ ఫ్రమ్ 1 to ఎన్ని సెక్షన్ వరకు నడుస్తుంది? ఏంటిది? జనరల్ ప్రిన్సిపల్ ఆఫ్ లా ఆఫ్
72.
కాంట్రాక్ట్
72,
72.
75.
75 is the right answer. See, this is a common question. You are supposed to know it because some questions, I am sure that if such a question will be asked or be there, you should be in a position to give the answer. Yes, read the 35. Anyone? Unmute and read.
How many
How
chapters
many
are
chapters?
there?
Under?
Then
General
general
principles of contract.
ఎన్ని చాప్టర్స్ ఉన్నాయండి జనరల్ ప్రిన్సిపల్ ఆఫ్ కాంట్రాక్ట్?
6.
6 ఉన్నాయి దాంట్లో. ఓకే, నెక్స్ట్ ఈజ్ ప్రిలిమినరీ. ద ప్రిలిమినరీ సెక్షన్ 1 to 2 కమ్స్ అండర్ which చాప్టర్?
First chapter.
Chapter 1.
కావాలని పెట్టా నేను ఇది.
None of the above, sir. If preliminary does not contain
Chapter
chapter.
1 and 2, sir.
కావాలని పెట్టిన నేను అది.
Chapter 1 and 2.
కాదు, నన్ను అది
Oh,
మీరు చూడండి, ప్రిలిమినరీ చాప్టర్ ఎక్కడ వస్తుంది? ఆ చాప్టర్ కింద రానే రాదు, అది వేరే వస్తుంది చాప్టర్ కింద. ఇది కావాలని
Chapter
పెట్టిన.
2
ఎందుకంటే
and chapter
మనలో ఏం చేస్తారు గుడ్డిగా చాప్టర్ 1 వస్తాయి, ఎందుకంటే సెక్షన్ 1 కదా. డెఫినెట్ గా సెక్షన్ 1 అంటే చాప్టర్ 1 లోనే వస్తాయి. ఓకే, కావాలని పెట్టిన అందుకోటి అందరు తప్పుపడ్డారు అక్కడ. ఓకే, అండర్ విచ్ చాప్టర్ హయ్యర్ ఆర్ మాక్సిమం సెక్షన్స్ ఆర్ ప్రెసెంట్ ఇన్ ద జనరల్ ప్రిన్సిపల్ ఆఫ్ కాంట్రాక్ట్ 1872?
chapter 4.
ఇది చాప్టర్ 4 లో ఉంటాయి. మాక్సిమం నెంబర్ ఆఫ్ ది సెక్షన్స్ ఆర్ దేర్ ఇన్ ద చాప్టర్ 4. ఇక్కడ ఫీడ్బ్యాక్ లో కూడా ఇచ్చాను చూడండి. చాప్టర్ 1 7, చాప్టర్ 2 22, చాప్టర్ 3 6, చాప్టర్ 4 31, చాప్టర్ 5, చాప్టర్ 6 3. హైయెస్ట్ దేంట్లో ఉన్నాయండి? ఇప్పుడు 4 లో ఉన్నాయి చూడండి. ఇవి సబ్సిడరీ క్వశ్చన్ కూడా అడగచ్చు ఇందులో. లీస్ట్ ఎందులో ఉన్నాయి చెప్పండి ఇప్పుడు?
3. 6.
అవి 3 నెంబర్, అది చాప్టర్ 6 చెప్పాలా? రైట్ ఆన్సర్. ఓకే, వైడ్ అగ్రిమెంట్స్ అండర్ ద ఇండియన్ కాంట్రాక్ట్ యాక్ట్ 1872 స్టార్ట్స్ ఫ్రమ్ సెక్షన్ టు సెక్షన్. ఏ సెక్షన్ నుండి ఏ సెక్షన్స్ కు వైడ్ అగ్రిమెంట్ స్టార్ట్ అవుతాయి? ఎస్, విచ్ ఐ షోన్ ఆన్ ద స్క్రీన్. 24 to
24 to 30.
the answer right is 24 to 30 is the right answer. 24 to 30 is the right answer. Wide agreements, it starts from 24 and ends with the 30. That is the right answer. Yes. Of certain relations resembling those created with the contract also be known as
Quasi contract.
quasi contracts. Subsidiary question. Quasi contract runs from which section to which section? Yes. చెప్పాలా? 64 నుండే 65 నుండే ఏ సెక్షన్ నుండి ఏ సెక్షన్ వెళ్తాయి?
68 to 72, sir.
I think that is the right answer. Let me check it. Whether you are right or not, I will make it quasi contract. Quasi contract from which section to which section? 68 to 72 is the right answer. Agreed? So, feedback lo petteste emaitadi? Yes. Quasi contract, this is comes under the, yes, dini. Acha, what is the subsidiary question? What is the adhesive contract? Anyone? Subsidiary question idi. Subsidiary question idi. అడెసివ్ కాంట్రాక్ట్ ని ఏ కాంట్రాక్ట్ ని అడెసివ్ కాంట్రాక్ట్ ఎగ్జాంపుల్ చెప్పండి. ఎస్ ఎగ్జాంపుల్. అరే బాబు, స్టాండర్డ్ ఫార్మ్ ఆఫ్ కాంట్రాక్ట్ అండి. ఇన్సూరెన్స్ కాంట్రాక్ట్ మొత్తం అడెసివ్ కాంట్రాక్ట్స్. ఇన్సూరెన్స్ కాంట్రాక్ట్స్ మొత్తం అడెసివ్ కాంట్రాక్ట్. బాటమ్ లైన్ ఇస్ లో, బాటమ్ లైన్ ఇస్ హై టు ద ఇన్సూరర్ కు ఉంటుందా, ఇన్సూర్డ్ కు ఉంటుందా? ఎస్, హూ ఇస్ హ్యావింగ్ ద హై బాటమ్ లైన్ ఇన్ ద ఇన్సూరెన్స్ కాంట్రాక్ట్? ఇన్సూరర్ కు ఉంటుందా, ఇన్సూర్డ్ కు ఉంటుందా అండి? ఓ
Insured, sir.
ఇన్సూర్డ్ అంటే ఎవరైతే పాలసీ తీసుకుంటారో వాళ్ళకు ఉంటుంది. వాళ్ళకు హై బాటమ్ లైన్ ఉంటుందా, లేకుంటే ఎవరైతే స్టేక్ హోల్డర్ ఉంటుందో ఇన్సూరర్ వాళ్ళకు హై బాటమ్ లైన్ ఉంటుందా?
Insurer కి ఉంటది సార్.
ఇన్సూరర్ కి ఉంటది. మరి దానికి ఇంతసేపు చేస్తున్నారేంటి? సార్ మాకు తెలియదు సార్, ఎవరైతే ఇన్సూరర్ ఎవరితో ఇన్సూర్ సార్, అందుకోసం మేము కన్ఫ్యూజన్ అయ్యాం సార్, అందుకోసమే మీకు చెప్పలేదు సార్ మీకు. Okay, that is the answer for that one. So high bottom line, adhesive contracts are thus a contract. All contracts of the insurance is adhesive contract or standard form of contract. ఇప్పుడు subsidiary question another. What are the other name for the standard form of contract అంటే ఏం చెప్పాలా?
Adhesive contract.
Adhesive contract అనాలా. What is the another name of the quasi contract అంటే ఏం చెప్పాలా? అవి ఈక్విటీ, బేస్డ్ ఆన్ ఈక్విటీ కాంట్రాక్ట్స్. ఇవి ఏది? క్వాసీ కాంట్రాక్ట్స్. ఆర్ యూ ఫాలోయింగ్ మీ?
Yes, sir.
Yes.
ఎస్, ఈక్విటీ ప్రిన్సిపల్స్ ఉపయోగిస్తాయండి. ఇది ఒక ఎగ్జాంపుల్ చెప్పండి. అడెసివ్ ఇది క్వాసీ కాంట్రాక్ట్ ఎగ్జాంపుల్ చెప్పండి.
Reimbursements.
రీఎంబర్స్మెంట్ ఆఫ్ కోర్స్. ఏ బి ఇచ్చి తీసుకున్నారు అనుకోండి, వాడు ఏకి తెలక సికి ఇచ్చిండు. బి మొత్తం 100 రూపాయలు ఇచ్చిండు సికి. ఏబి ఇద్దరు కలుసుకుని పెంచుకుండు 50 రూపాయలు. కానీ ఏ మొత్తం 100 రూపాయలు సికి ఇచ్చిండు. సో ఎట్ ద టైమ్ ద బి విల్ గెట్ ద బ్యాక్, ఆర్ ద సి షుడ్ హావ్ టు సపోజ్ టు రిటర్న్ ద 50 రూపీస్ టు ద బి, బికాస్ ఏ ఆల్రెడీ పేడ్ ఓవర్ దే. ఇది క్వాసీ కాంట్రాక్ట్. ఇందులో ఆఫర్ అండ్ యాక్సెప్టెన్స్ ఉండదు. ఓకే, కమ్ టు ద నెక్స్ట్ పాయింట్. టైమ్ అండ్ ప్లేస్ for performance comes under which chapter of the ICA 1872?
Fourth.
Sir, finder of the goods, main is quasi contract, finder of the goods.
Finder of the goods would cause a contract కిందనే అవుతాయి, because he has to return if they find the true owner of the contract, true owner of the goods. Okay, what is the time and place? ఏ చాప్టర్ కింద వస్తాయి?
Fourth chapter, sir.
It is comes under the yes 6th chapter కింద వస్తుంది. టైమ్ అండ్ స్పేస్. Check it whether right or wrong. And which one is not considered as an element of a contract? ఇది
Sixth is
చెప్పాలి.
breach of contract, sir.
Sir,
Eh?
counter offer, sir, counter offer.
కౌంటర్ ఆఫర్ అండి. అక్కడ బ్రీచ్ ఆఫ్ కాంట్రాక్ట్ లేనే లేదు అక్కడ. Which
No,
one
sir,
is
I'm
not?
talking about chapter 6.
అచ్చా, చాప్టర్ 6 బ్రీచ్ ఆఫ్ కాంట్రాక్ట్స్ వస్తుంది. ప్లేస్ అండ్ let me check it now. Let me check.
Chapter 4 is
Mhm. Okay, chapter 4
of ICA.
Indian Contract Act. Okay, now let me see. Indian Contract Act proposed a letter to sell the house. This is chapter 4. So now let us see the chapter 4, 6, where the agreements are there, impossible things are there. Now the question comes over there. As per the new rule is concerned, our rule is concerned. Suppose that you have purchased the online from the Hyderabad, the goods manufactured in the New York. Where do you have the right to file a suit?
Hyderabad only, sir.
Why? What is the ground?
Purchase.
Because it is delivered from Hyderabad.
The question is, the property is delivered from the Hyderabad and the person has purchased in the Hyderabad. That means lex loci అంటారు దాన్ని. ఏమనాలండి?
Lex loci.
లెక్స్ లోసి అంటే లా ఆఫ్ ది ప్లేస్ అన్నట్టు.
And one
Jurisdiction.
more thing, sir, that person Hyderabad the deliverer, he
Hmm.
can sue the company in America.
No, the defective goods are concerned, for instance, because we will study in the private international law this thing. Suppose the defective goods, the G and what is you know the G and M General Motor Company,
Hmm.
they manufacture Chevrolet.
Yet in USA based.
Is it Chevrolet? No,
Chevrolet, that is mm,
no, because we have the case law, but they have a branch office, the manufacturing office there in America, Chevrolet
yeah,
head office or manufacturer.
Detroit.
We will see Chevrolet who manufacturer.
Detroit, it is in Detroit, I think.
Yes, Sarvan Road. So what point me? The manufacture the things in one place, and
It is
it is sold in India, and the purchased person from the India at that instance, and accident took place, say about in Nepal. So at that instance, how the action would be there? So there we will say that even though the accident took place in Nepal, and it is purchased
he
in
has to
India.
sue the person. He has to sue the person in India, sir, because it is delivered from India.
There the question comes over there. The jurisdiction is having is India only, not Nepal. Even though the accident took place there.
One more thing is, sir,
Yeah.
even if it is if the things are manufactured in USA,
Yes.
they are assembled here.
You are true. You are true. You are true.
So the responsibility lies with the person who is assembling here.
Yeah. Even no, in some countries they don't assemble it because directly they come on the cargo ship directly.
Okay. Anyhow, the deliverer is responsible.
Yeah. The delivery is responsible. For instance, you take the Tanzania, nothing is manufactured over there. The whole cars are directly come from the Japan to the port of Dar es Salaam.
Okay.
Yeah, because they will sell in the Dar es Salaam, but the seller would be there, agent would be there in the Dar es Salaam, and he will sell the things. At the time, if there any manufacturing defect would be there from the Toyota company, because the most of the cars were from the Toyota there. So the most of the at that instance they will make a party to it, and they will make party to the manufacturer also, and they will sue it in Dar es Salaam only, the jurisdiction. So today's regarding the contract is concerned. Thank you very much for your patient listening. And tomorrow I will post you what I am going to deal it because there are many subjects are there. Of course, in the contract you will get only 3 or 4 questions, not more than that. But still, you
Thanks
have
a
to work
lot,
hard.
sir. Thanks.
Yeah.
Thanks a lot.
And
sir.
because your participation is an encourage to me because the time is short and there are many subjects are there. Hence, I would like to deal every day, including the Sunday. Unless until I do have any other work would be there, I will postpone from the day to evening or evening to day. But my class is there unless until say to year. Thank you very much for your patient listening, and we will meet you
Thank
again
you very much.
on the same timings unless until there is a change in the times. Yes. Very good. Very good.
Thank you, sir.
Yes,
Have a
sir.
nice
Yes,
day.
sir. Yeah, nice day, sir. Nice day.
Thanks,
Good.
sir.